the Constitution provides for how these matters are to be dealt with. And so you have no discretion to decide to, as it were, breach the Constitution because you feel that you want to waive that right. That right, if it's granted, amounts to she and the Supreme Court colluding to breach the Constitution. And I think that is what the Supreme Court would have to guard against.
Okay. So stay with me. I want to bring in John Darko. John Darko, give me your own thoughts on this.
All right. Thank you. Good evening to your viewers. I think it's very interesting that when it suits us, we think that the Constitution is so entrenched, and when it doesn't, then we believe that we can step aside the constitutional provision. But in this country, less than 2 weeks ago, when the president left the country, when he knew that the Speaker of Parliament was not in town, the Vice President was not in town, the constitutional provisions and the case of the same Asari Attorney General, the Supreme Court had interpreted the provisions so clearly that you couldn't leave the country without swearing in either the Speaker of Parliament to act. But the President left the country breaching the constitutional provision, violating the constitutional provision, and we didn't hear our brothers, or at least the panelists here, condemning the breaching of the constitutional provision. And so sometimes I wonder why we always want to do this to ourselves. We want to treat the Constitution, as if it's a convenient document that
is there a constitutional? Is there a constitutional basis to waive that clause that says this process must be held in camera?
So look, if you look at Article 146A8, which talks about the fact that the committee shall sit in camera, I think it is the basis for which my co-panelists are saying that the provision is so clear and that we cannot do anything about it. But we know that this same Supreme Court, our Supreme Court, has interpreted shall, okay? Because we are talking about the fact that the Constitution says it shall be in camera. The Supreme Court has interpreted shall to mean not that provision may not necessarily be binding. I mean, in the Akufo-Addo and Mohammed's case, we know how the Supreme Court interpreted shall. And so the fact that Article 146.8 says that the whole act shall be held in camera does not necessarily mean that we cannot interpret that to mean that this should be open to the public. Look, this is a matter of public importance. And if you look at our provisions, Article 281, this is more like a public inquiry. And the law is very clear that when it comes to public inquiry, unless it's going to be against public order, public morality, or public safety, these kinds of hearings must be in public. And so I don't think that it is so rigid, so difficult that we cannot grant that request. Look,